Yama, good afternoon and welcome to the National Library of Australia. I'm Dr Shirlene Robinson, Director of Curatorial and Collection Research. I'd like to begin by acknowledging Australia's First Peoples as the traditional owners and custodians of this land and give my respect to elders, past and present, and through them, to all Australian Aboriginal and Torres Strait Islander peoples. Thank you for attending this event, coming to you from Ngunnawal and Ngambri country. This afternoon's presentation, Consent on Trial, the fascinating case of the Maria Luz Incident, 1872, is Dr Bill Mihalopoulos, a 2021 National Library of Australia Fellow. Our Distinguished Fellowships program supports researchers to make intensive use of the National Library's rich and varied collection through residencies of 3 months. National Library of Australia Fellowships are made possible through generous philanthropic support, and Dr Mihalopoulos' scholarship is supported by the Harold S. Williams Trust for Japan Studies. Dr Mihalopoulos received a PhD in history from New York University and is currently lecturer in Asian Pacific Studies at the University of Central Lancashire. In 1872, the fledgling Japanese government found itself embroiled in an international incident when asked to arbitrate on whether 230 Chinese indentured people on board the Peruvian bark Maria Luz were free labourers or slaves. Matters became even more challenging for the Japanese government when it was accused of tolerating domestic slavery in the institution of licensed prostitution. In this presentation, Dr Bill Mihalopoulos investigates how Japan responded to these challenges that crystallised around this so-called incident and uses it to investigate the rare moment when consent in contract, a fundamental concept that defines the modern world, was introduced and modelled in Japan. So if you could please join me in welcoming him to the stage today.
Hello everyone, thank you for taking time to be here today. Before I begin, I'd like to acknowledge Australia's First Nations people, the first Australians as the traditional owners and custodians of this land, and give respect to the elders, past and present, and through them to all Australian Aboriginal and Torres Strait Island people. So I first came across the Maria Luz incident when many moons ago, when the dinosaurs were roaming the earth when I was an undergraduate. And it was through Japanese feminist historians' work on licensed prostitution. And they saw the Maria Luz incident as a failed attempt at bringing fundamental reform to a long tradition of licensed prostitution in Japan. And it's been something that has sort of been working through various stages. And I'd like to thank the Harold S. Williams Trust for allowing me to have this time to think about it and share with you the frustrations and rabbit holes I've gone through in the last month. Now, normally when we talk about the Maria Luz incident, we tend to focus on issues of whether it's slavery or not. However, I take a slightly different direction, and I see the Maria Luz incident as an encounter with one of the unresolved dilemmas within liberalism, which is the contradiction between the commitment to liberty of persons with a commitment to the liberty of contract and work relations. And what that basically means is, in liberalism, we believe that individuals should be free, and we also believe that individuals should be free to enter into work contracts. But once you enter into work contracts, there's all these kinds of restrictions on what you can do and you can't do. And a good case in point is, at the moment, if you try and be very critical of your employer, you most likely end up being fired because it's seen as against their interest. So the other thing that makes this case fascinating is that the proceedings were conducted primarily in English, despite the judge and the defendants and the litigants all not speaking English, and that the 2 trials were overseen by the Japanese Foreign Ministry and not the Japanese Justice Minister. So let me just start with oops. It's not working, guys. Oh, here we go. All right. So let me just start with giving a bit of background. On the 11th of July 1872, the Maria Luz hobbled into Yokohama port for repairs, and it was an event produced by chance. The captain of the vessel, Ricardo Herrera, reported to the custom officers that the Maria Luz carried 230 free immigrants in passage for Peru. And allow me at this moment to thank Mr. Chung Mao Shu for allowing me to use this wonderful photograph of one of the few representations I've seen of actual Chinese labourers on a ship. This was not Herrera's first commission to transport a human consignment from Macau to Peru. A lieutenant of the Peruvian Navy, Herrera had spent the last 5.5 years in command of so-called coolie vessels with Peruvian government sanction. And when we talk about Peru, what a coolie ship or vessel means, it's ships specially decked out in the hold to carry large numbers of labourers and also to be able to shackle them when necessary. By his own admission, he had shipped some 3,000 Chinese labourers to Peru, and it was common practice for captains of ships, coolie ships, to buy the services of Chinese labourers on private speculation. Over the course of his 6 voyages, Herrera returned to Peru with 130 Chinese men, boys and girls, allegedly recruited to work on his family estate as labourers or servants. His commission with the Maria Luz was no different. While moored in Macau, Herrera negotiated service contracts for 12 boys and girls under 15 years of age to work as house servants. Now, the key dilemmas of the Maria Luz incident is who has jurisdiction over a vessel that has sought shelter in a foreign port because of bad weather or mishap at sea. And this ambiguity can be traced back to efforts to prohibit slavery and the US position and the US antagonism with Britain over where these lines of jurisdictions lay. From 1815, the position of the United States determined to protect its sovereignty by remaining outside international treaty regimes set up by Britain against slave trading was that vessels flying an American flag came under jurisdiction of American law. The property and relations of persons on board vessels fell outside local national laws. In contrast, the British position was that while the law of nations gave stricken vessels exemption from local laws, it did not confer immunity. If illegal acts such as the transport of slaves was committed in British waters, then the extent of the immunity fell to local courts to investigate and adjudicate. So there's a conflict here of who's in charge when you have a vessel that comes into port in distress and which laws apply. The second complexity to this case is the legal standing of the Chinese labourers. The labourers on board the Maria Luz occupied the in-between space of being both passenger and the freight Herrera was commissioned to transport to Peru. The third added layer of complexity was a lack of universal legal consensus over what constituted freedom, especially when it came to indentured labour contracts. From 1841 to 1917, Great Britain had created a massive system of laws and local ordinances that facilitated the conveyance of indentured labour, officially referred to as voluntary and spontaneous free emigration. The United States, however, demarcated the legal boundary between voluntary labour and slavery differently. In 1862, the US Congress introduced prohibiting American citizens from procuring and transporting Chinese indentured labourers because it subjected them to oppressive work conditions that amounted, in their words, to slavery. So what fascinates me about the Maria Luz incident is that it offers one of these rare moments in history when we see these fundamental concepts such as consent, freedom and slavery made and refashioned in front of our eyes. Now, the application of law does not happen in a vacuum. To be effective, law must be seen as expressing the facts of the world. Legal judgment also involves interpretation based on precedents accumulated in past cases. This was especially true for the two hearings that generated the drama of the Maria Luz incident. Most of the foreign diplomatic community residing in Japan believed the Japanese government lacked the authority to intervene in events that occurred on board the foreign vessel. To quiet diplomatic agitation, the Japanese Foreign Ministry ensured the provisional hearing and subsequent two civil suits adhered to established Western legal norms. Legal arguments in both hearings were made by qualified British barristers. Moreover, in the civil hearing, both barristers adhered to the mid-century British common law understanding of service contracts as embodying voluntary and consenting labour. And it's to this understanding now I want to turn to. British notions of indentured labour migration as free immigration crystallised around a social imaginary that constructed freedom narrowly to the anti-slavery prohibition of ownership in persons. Crucially, anti-slavery rhetoric resonated with contemporary British economic debates. By the time of the passing of the Slavery Abolition Act of 1833, slavery was equated with despotism and economic autocracy. Free trade was equated with voluntarism and consenting labour. In the process, the material value attached to people transported to the colonial plantations in the Atlantic and Indian Oceans also mutated. Those who were transported now no longer were defined as property for agricultural and domestic work, but were reconceived as an item of exchange, this thing called labour, whose value was determined by the forces of supply and demand. The first migration of contract labour was the transportation of Indian labourers to the British plantation colony of Mauritius in 1834. And this system also provided the prototype for the practice to be replicated elsewhere. Individual Indian workers were recruited in their native domicile and transported to plantation colonies for a 3 to 5 year term of service. The move from slavery to indentured labour contracts followed a well-established judicial template. From the 1800s, English law framed the performance of manual labour as a contractual economic relationship, which simultaneously defined the work relationship between manual worker and employer as the performance of service via pre-capitalist master-servant laws. The master-servant laws were very specific. They only applied to manual labourers who relied on wage work for survival. The use of indentured labour to replace slave labour coincided with the proliferation of almost 2,000 master-servant statutes and ordinances in more than 1,000 British colonies, including the one that now we're standing on. As indentured labour came under master-servant laws, work relations were not based on any formal conditions of contractual equality. For the indentured labourer, the freedom was very narrow. It was no more than the choice to become a law-abiding price taker for their labour. Getting paid a wage, however, meant consenting to serve another. Master-servant laws gave the employer command over the indentured labourer while simultaneously granting the employer the freedom to draw up existing colonial laws and regulations to compel work. Excuse me. The liberty given to the employer included melting out corporal punishment, levying fines, forfeiture of wages, and in extreme instances, calling on local magistrates to enforce imprisonment if work quotas were not met. The initial challenge for the British government in enabling and facilitating the transport of indentured labourers was how to keep it unsullied from the horrors of the Middle Passage. This was a multi-layered problem. First, plantations still followed the same production procedures that existed during slavery conditions. Second, the plantation continued to be organised around the same division of labour as slavery, where people of colour did hard physical work and Caucasians managed. Third, there were no provisions for enforcement of contractual arrangements to prevent abuse. The concepts of good faith and mutual trust essential to the criteria of consenting contract were not statutory elements, thus leaving enlisted labourers open to abuse. The British government's response to this problem was technical, administrative, rather than trying to establish new rights for workers. Government tinkering began in 1842 when the recruitment and transportation of Indian indentured labourers came under government control to prevent irregularities that could be misconstrued as slavery. The markers of slavery were high mortality rates at sea, speculative labour ventures that auctioned human freight in public marketplaces, and the physical abuse meted out by plantation owners. Before long, a sprawling bureaucratic system developed across the British Colonial Office, Land and Immigration Commission, and various colonial governments. Detailed regulations were incrementally applied to cover all aspects of recruitment, passage and return of the indentured labourers. Key to this system was official scrutiny of the conditions of contract, which involved confirmation by both parties that they were clear about the terms of engagement in front of a salaried British official. By the 1850s, British public opinion was trumpeting indentured labour as spreading the virtues of the free labour time wage system across the span of the world. The offering of regular wages, it was asserted, created the conditions of liberation and betterment to the peoples of Asia caught in a state of poverty and destitution. British legislators, bureaucrats and publicists were convinced that any system of contracted labour applied to the new part of the world without the same level of oversight and regulation would degenerate into a speculative venture and easily lapse into a trade characterised by fraud and kidnapping. Now, Britain was not the only country to experiment with indentured labour migration. Peru too turned to immigration labour to replace slavery when South China emerged as a major trading hub for global labour in the 1840s. From 1849 to 1874, an estimated 92,000 Chinese labourers were transported to Peru by Spanish-speaking agents. Moreover, from 1857, Macau became the major embarkation hub for Chinese labour earmarked to work in Peru. Both Britain and Peru benefited greatly from the global indentured labour system promoted and encouraged by both sets of government. However, by 1854, the British public was condemning the labour trade operating from Macau to Peru as a new form of slavery. It is important to note that the British censure did not deal with the issue of indentured labour migration per se, but rather the weight of condemnation fell on the fact that the regulatory mechanisms were not fit for purpose to deal with the endemic cruelty that defined the Macau-Peru trade in Chinese labour. The next event that sort of causes this issue to intensify was in 1859, when the British officials in China adopted a policy of active intervention in labour trade occurring at Chinese ports. The change in policy was driven by British geopolitical concerns that linked the protection of British gains in China to the survival of the Qing Empire after the end of the Second Opium War, which was fought between 1856 and 1860. At the same time, Macau became the major labour trading hub in China. Private European labour agents based in Macau subcontracted recruitment to local Chinese brokers. The local brokers worked on commission and often resorted to crimping, which was kidnapping, trickery, intimidation and violence, to supply able-bodied men to the barracoons in Macau, a practice that successive British consuls identified as subject to penalty under the Slave Trade Acts. The local brokers were particularly active in the Guangdong province, which fed the anti-foreign agitation and unrest in the trading port city of Canton. British officials in London and China feared that the disorder and unrest generated by the unregulated trade in Chinese labour, coupled with the volatile situation in Guangdong province, would jeopardise the gains secured by British interests via treaties. To offset this danger, the British established a system of immigration regulation with the consent of other European consulates residents in Canton. Widely known as the Canton system, government-registered immigration houses acted as clearing houses for Chinese labourers wanting to work abroad. Before any potential migrant was given a certificate to travel from Canton, British and Chinese officials would scrutinise the willingness of prospective migrants to work under contract to ensure that the parties themselves really consent to the arrangement. At the same time, the British legation in Canton identified labour immigration from Macau as illegal and as a form of slave trade disguised as free immigration. Despite British diplomatic pressure, the trade in Chinese labour became Macau's main source of revenue. By 1861, Macau was the primary departure port for Chinese manual labourers bound for Spanish Cuba and Peru under contract. Successive colonial governors began introducing regulations that dovetailed with the procedures established by the British in Hong Kong and Canton to escape further international censor. Despite the best efforts of the Macau authorities, however, the Portuguese settlement's labour trade to Latin America remained notorious as a new form of slave trade in the British imaginary. A primary reason for this was the wide dissemination in public bulletins of the personal observations by British diplomats and medical officers and judges stationed in China that asserted that the labour trade from Macau to Peru was a form of slavery run for the benefit of a few foreign Spanish-speaking labour agents. The reports constituted an expose on the corruption and slapdash enforcements of regulation in Macau due to the vested public and private interests. The reports narrated how vulnerable Chinese men were deceived or kidnapped by local crimps, transported to Macau, whereupon they were herded into grimy barracoons under armed guard, threatened by foreign immigration agents, and made to sign contracts they could not read or understand, and bundled on board ships against their will. Details coming from Peru were also disapproving. Local press articles and intelligence sent back by British consuls told of Chinese labourers brought and sold into public auctions to life, completely at the mercy of masters beyond the restraints of laws. Masters who ill-fed them, confined them, confined them to barracks under armed guards when not working, and who branded them with irons in the same fashion as slaves. It was these types of reports that inflamed British passions, leading to public calls for the government to use its power to suppress this infamous trade in trafficking in Chinese people. The British government's position was that it had no authority to stop ships sailing from Macau to Peru. Britain was able to make the abolition of slavery into an international agenda via binational treaties with other countries, including Portugal. These treaties gave the British Royal Navy the right to intervene if a ship was suspected of being a slave trader. However, as such binational treaties did not exist in the case of the so-called coolie immigration, regulation was a matter for local national laws and not international law. Consequently, the British government's position was that it had no right of interference except to give friendly advice to other governments as it thinks fit. And it was this British friendly advice that shaped Japan's response to the Maria Luz Incident. The Maria Luz Incident was under charter to the Labour agent Nicholas Tanco Amero, who had a very infamous reputation as being one of the major traders in Chinese labour to Cuba and Peru. And he had consigned Herrera to transport a cargo of contract labourers. On completion of the journey, Herrera was to receive £14 for every contracted labourer who survived the journey. And if everyone survived, it was a total of more than £3,000. However, if Herrera was unable to complete his commission, he was liable for £1,000 for breach of contract, according to the terms of agreement. The Maria Luz's consignment was 238 indentured Chinese labourers. By the time it reached Yokohama, it was 230. 7 people had died by jumping aboard, committing suicide, and 1 person had succumbed to illness. And the suicide rates on these ships was quite significant. On the 9th of June 1872, the Maria Luz encountered a severe storm in open water that left it without foremast and a damaged mainmast. 3 weeks later, on the 11th of July, the vessel limped into Yokohama port and moored a half a mile away from shore for repairs and away from all other ships anchored there too. It kept her distance from all other vessels, and none of the Chinese men were allowed to alight. Despite Herrera's best-laid plans, events took an unexpected turn. In the early morning of the 13th of July, the crew of the English warship Iron Duke rescued a man floating alongside the flagship in an exhausted and drowning state. The rescued man indicated he had jumped overboard from the Maria Luz, anchored some 500 metres away. He also claimed that his countrymen had been entrapped, kidnapped, and put on board the Maria Luz against their will. The next day, the captain of the Iron Duke placed the man in care of Russell Robertson, the British consul at Yokohama. Robertson duly handed the man over to the local Japanese officials. The Japanese authorities summoned Herrera, who immediately demanded the Chinese man be returned to his charge. The Japanese authorities agreed, but not before gaining assurances from Herrera that the man would not be subjected to any punishment. And at this point, the Japanese authorities considered the matter closed. But concerns about the well-being of the Chinese men on board the Maria Luz refused to go away. On the 20th of July, another man jumped overboard and was rescued by the Iron Duke and asked for protection and not to be sent back to the Maria Luz. The captain of the Iron Duke decided against transferring the second man to the Japanese authority. Instead, he had the ship officers do a whip around amongst themselves, collect some money, and then they set him on shore at liberty. A few days later, Sir Edmund Hornby, the Chief Judge of the British Supreme Court for China and Japan, who was in circuit in Yokohama, contacted the diplomatic attaché of the British legation, Watson, on the circumstances of the second rescued man and several other Chinese men who had swum to shore from the Maria Luz. Hornby reported that Herrera had led an armed crew to shore, forcibly recaptured all the men and returned them to ship under armed guard. Hornby's interest in the events unfolding around the vessel were not arbitrary. His first post was as commissioner of a mixed British and American commission between 1853 and 1855, established to settle outstanding individual claims between Britain and the United States. One of the cases Hornby was asked to arbitrate was a claim by American slave owners for compensation for slaves liberated by British officials on board the US merchant vessel Enterprise. The vessel was active in the US antebellum domestic slave trade, where surplus slaves from markets in the Upper South were sold and transported to plantation owners in the Deep South. The case of the Enterprise shared many similarities with the legal issues crystallising around the ill treatment of the Chinese men on board the Maria Luz. Hornby and Watson paid a visit to the Japanese Foreign Minister Soejima Taneomi to discuss the treatment of the Chinese men on the Maria Luz a few days later. They found him in an agitated state at the audacity of Herrera to lead a crew of armed men on Japanese soil with no regard for Japanese sovereignty. Hornby took the opportunity to convey to Soejima that Japan had the right to intervene in the matter. Peru was a non-treaty nation, and thus the matter fell under Japanese jurisdiction and could be dealt under local law. It would be naive to inscribe Hornby's actions solely to altruism. He saw the Maria Luz incident, the Maria Luz case, as an opportunity to curtail the trade in Chinese labour from Macau to Peru by inserting English practices within the new hybrid legal system taking form in the Yokohama foreign settlement. Soejima's decision to intervene in the Maria Luz case also was heavily influenced by American lawyer Erasmus Persign Smith, who was a diplomatic advisor to the Foreign Ministry from 1871 to 76. Smith advocated Japanese jurisdiction over the Maria Luz incident as a way of defending, asserting, and expanding the national sovereignty of Japan, which dovetailed with Soejima's national rights diplomacy that characterised his tenure as foreign minister. Smith had prior experience in dealing with the issue of the so-called coolie question before taking up his post in Tokyo when he was US Commissioner for Immigration in 1864. During his tenure as Immigration Commissioner, Smith continued to align immigration policy with the Anti-Coolie Act of 1862, passed by, designed to prevent American plantation owners from replacing African-American slaves with unfree contract labour from China. What's important to note is that while Hornby and Smith, both experienced legal experts, prescribed the need for Japanese intervention, they embodied two incompatible legal approaches to the issue of consent, voluntary labour, labour migration regulation, and what constituted freedom. Hornby's legal template was a utilitarian approach to the administration of law that typified English judicial process. The regulation of indentured labour was a technical matter, the right balance between control and freedoms, benefits over harm. Good regulation ensured that the contractual arrangement embodied consent, while simultaneously creating the optimum balance between the material needs of the labourer and the demands for labour by the capitalist planter. Smith, on the other hand, personified a rights-based approach. His position was that the worker's right to quit was a non-negotiable principle of freedom and could not be discounted or compromised, no matter what the objective. So after that, Soejima was granted authority to form an ad hoc court to look into the matter, and he appointed the Assistant Council of Kanagawa Prefecture, Oyataku, to form the court and inquire to the matter under his guidance. Right, so the preliminary investigation followed the well-established legal tenets of 19th century mixed commissions. The mixed commissions were based on British prize law. The rules and regulations of these commissions protected property rights over slaves and ships and allowed slave traffickers the defence of challenging the legitimacy of legal proceedings. And as we shall see, the Maria Luz hearing followed suit. Initially, the hearing focused on the Chinese labourers who had jumped ship. The first to be deposed was Mo Hing, the first Chinese labourer rescued by the crew of the Iron Duke. He was deposed on the 7th of August. In his deposition, Mo Hing claimed that he was forced into the Maria Luz lying off Macau, where he was locked up and very badly treated by the captain and had his queue cut off as punishment. He jumped ship when the vessel anchored in Yokohama, as he did not wish to die on the vessel and made the effort to escape. Moore also stated that he was made to sign a contract under duress. He only came to understand that the terms of the contract were for 8 years of service to far off Peru after the vessel left Macau. Herrera was also invited to give a deposition on the same day. In his statement, Herrera denied the charge of cruelty. He confirmed that Mo Hing was a passenger on the ship, but at the same time, Mo Hing was also freight in transit and a unit of profit. He admitted to cutting Mo Hing's queue and putting him and several other men in irons while anchored at Yokohama, but the intentions of his actions were to secure the conditions of his contract with Tanco Armero and devoid of malice. If he did not prevent the Chinese labourers from escaping on the voyage, he stood to lose passage money and the expense of their sustenance during the voyage. The investigation reconvened from the 19th to 24th of August. This time the inquiry was more formal and held in the presence of other foreign consulates. Herrera in turn employed Frederick Dickerson, an English barrister, as his legal counsel. John Davidson, another English barrister, represented the Chinese labourers, and his fees were paid by the local Chinese Merchants Association. On the 22nd of August, Oye ordered all male Chinese passengers to be brought to shore under the protection of the Japanese authority while the captain was under arraignment. And now this is the most controversial part of the incident. And we have to remember that these people are in the in-between space of being passengers and also cargo. And the seizure of cargo is it's a trigger point in a lot of these colonial interactions. And it has to be remembered that the reason the first Opium War started was because the Chinese authorities confiscated the cargo of British and American subjects. All right. The reason why the main reason why the Chinese passengers were brought to shore, well, there's two reasons. One was they feared that Herrera would leave in the middle of the night before the trial was over. And the second was because the Yokohama Chinese Merchant Association had petitioned the Japanese authorities to extend the scope of the inquiry to include all Chinese labourers on board the Maria Luz, to give them the opportunity to request protection. The court interpreted the appeal as equivalent to a writ of habeas corpus in British law, namely a legal request to investigate by what right was the liberty of men on board the Maria Luz curtailed within Japanese waters. Now, Dickens' argument for Herrera's defence was conveniently summarised in a letter to the editor of the English-language Japanese weekly Mail, which, by all suspicions, probably was written by Dickens himself. Namely, that Japan did not have the authority to seize the Maria Luz nor to transport the Chinese labourers on shore, and that such actions were tantamount to the total confiscation of the ship and cargo. On the 30th of August 1872, Oyer formally announced his findings. Oyer declared that the charges against Herrera for the abuse and forceful restraint of the Chinese men were fully sustained. Yet, as often happened in mixed commissions, as always happened in mixed commissions, Herrera escaped punishment. The cost and delay caused by his enforced stay in Yokohama harbour was considered punishment, while expediently exempting Japan from any claims for compensation for expenses occurred because of the delay. Herrera was permitted to depart with his vessel along with any of the Chinese men who still sought to work in Peru. And none of the men or miners was willing to do that, and unsurprisingly, Herrera was reluctant to continue his journey without the Chinese labourers and miners on board, and he sought civil action. The civil trial was held almost a month later, from 18 to the 27th of September, and it consisted of two suits. The first was filed by Herrera as an agent of Tanko Admiral, and requested the court to enforce the indentured contracts of 230 Chinese labourers and have them returned to the vessel. The second suit was by Herrera against the 13 miners, also for breach of contract. Now, Davidson's defence for the Chinese labourers was that these contracts were not signed in good faith or mutual trust, but under fraud and duress, were unlawful under British common law, and it was impossible and highly dangerous for the men to continue their journey to Peru, and therefore they should be made invalid. Dickens countered Davidson's argument that the contracts were void and illegal under common law by arguing that the indentured contracts the Chinese men travelled on were not prohibited by existing Japanese law. He pointed to the fact that the terms of service of female performers, which we usually call geisha, and licensed prostitutes, strictly enforced by the Japanese government, were no different from the contracts signed by the Chinese labourers. Dickens noted the basis for licensed prostitution was equivalent to a civil contract for the for the duration of 6 to 8 years, which gave the brothel owner not only the authority to order women to perform service, but power on all aspects of their life. Moreover, the brothel owner had the power to sell the contract to a third party. Dickens concluded the indentured contracts the licensed prostitutes and Chinese labourers travelling to Peru were one of the same. Both sets of contracts were for duration of 8 years, transferable, gave the employer the right to enforce performance and to punish any breaches, and often were entered into with minors incapable of giving consent to them. Despite Dickens' ingenuity, the court dismissed both suits. The court found the contractual arrangements invalid and enforceable due to procedural reasons and on principles of laws. Now, I'm just going to skip that for a second because I'm running out of time. Now, this is taken at the Yoshiwara at the turn about 1990, and what we're seeing is actually a practice called harimise, where on the ground floor of these licensed brothels, you have latticeware and where people peer in and sort of look at the women who are there and sort of make their choice. Now, by 1890, the Yoshiwara had fallen into hard times. It wasn't as glamorous as it had been, and it was a very poor imitation of its heyday of the 1800s, where we see all these colourful costumes being worn. They're all practicing certain kind of calligraphy or artistic skill. And the whole point about going to the pleasure quarter was entertainment. Entertainment could be not just sexual encounters, but good food, good discussion, witty repartee with the women, dance, music, etc. And what we are seeing here is the Yoshiwara at its sort of height, where it was much more commercially viable and the centre of commoner culture in Tokyo. Right. So, more or less, so what happens is the Oya finds against Herrera. So in the wake of that judgment, Herrera deserted ship and fled to Hong Kong with the female miner in tow. The Chinese labourers returned to China, and the Maria Luz was broken up to pay outstanding debts. Now, the Japanese officials within the Foreign Ministry and Ministry of Justice were uneasy about the judgment handed down by Oya. Japanese licensed prostitution was organised around debt bondage, where destitute household heads used female dependents as collateral to borrow money from brothel owners. In return, the brothel owners gained legal and economic entitlement over the female dependent. The distinctive feature of this system of debt bondage was that although the debtor was the household head, the debt relationship was between the brothel owner and the female dependent. Japanese authorities feared the ruling would leave Japan open to claims for liability from the Peruvian government if contracts binding young women to serve in tea houses and licensed brothels continued to be in force. In response, the Council of State issued the edict for the release of female performers and prostitutes, the Shogi Keihore. The Shogi Keihore annulled all apprenticeships and agricultural labourers, indentured to service for 7 years or longer. So young boys were also indentured, but tended to be either in labour or other forms, such as being an acrobat or travelling performer. The ordinance also stipulated that all licensed prostitutions bound to a fixed terms of servants were therefore released, and the courts would not entertain suits by brothel owners on their debts. The Shogi Keihore edict is best understood in tandem with the ordinance issued on the 9th October by the Ministry of Justice, known as the Ordinance for the Release of Oxen and Horses, Yuba Kirihodokire. And this is infamous amongst Japanese feminists as just showing what Japanese men thought of women as being not but horses and oxen. Now, what is really interesting is Article 2 of the ordinance, which you can see above. The legal premise of the ordinance is highly instructive. The release of licensed prostitutes from any outstanding loans acknowledged that the existing service-type contracts treated the women as chattel. The analogy to beasts of burden is also highly significant. First, it established a clear legal distinction between property in person and property in beasts and things that wasn't found in Japanese law. Second, the ordinance introduced the notion of consent into the workings of contract. The ordinance directives were clear. One did not experience compensation from beasts of burden for not carrying out service because they lacked the capacity to consent to the work they're asked to perform. Likewise, one cannot expect licensed prostitutes to be liable for any outstanding debt, as the contracts were made without acknowledged consent. Existing licensed prostitute contracts were invalid because contractual arrangements did not embody consent. The hasty discharge of the licensed prostitute opened Pandora's box of practical problems for Japanese legislators. The most pressing was how to translate the regulations into practice. The different branches of the Meiji government offered competing solutions. The Minister of the Left, the legislative branch, interpreted the ordinances as issuing the closure of licensed prostitution as an occupation and identified the welfare and support of the released women as the most pressing issue. Operating on the assumption that the women employed as licensed prostitutes came from destitute families, the Minister of the Left advised the government was morally obliged to offer some form of poor relief to the women for taking away the immediate livelihood. The Minister of the Right concurred and proposed the constructions of orphanages for children and young women now left without means. In contrast, the Ministry of Justice determined the ordinance placed prostitution beyond any kind of government intervention. The edict for the release of female performers and prostitutes gave them the freedom to carry out the trade without restrictions or movement of place of abode. The position of the Ministry of Finance differed again. The Finance Ministry believed the decree gave the women the right to enter or leave prostitution at their own volition, nothing more. It was the Minister of Finance proposal that prevailed. By the early months of 1873, a room rental licensing system was beginning to be implemented in Tokyo and other cities and towns in Japan. Under this system, the prostitute was a licensed independent contractor who entered a contract with a room letting service, also known as a licensed brothel, to work as a prostitute. The advance of a loan by a brothel owner was to be repaid either by the woman herself or her guarantor, which in most cases was her immediate family. Highlighting the importance of consent in the terms of service, the Finance Ministry maintained that the women chose to work as licensed prostitute. The Finance Ministry proposal effectively transformed licensed prostitution into two different types of contractual arrangements based on a specific and narrow understanding of consent and choice. One, a service contract between women and a brothel owner which outlined the agreed upon services to be provided and the terms they were to be carried out. And two, the option for the women to enter a separate loan contract with the brothel owner, which would enable her to cover the initial costs required for her work by going into debt. So the replacement, let me just summarise where I'm at the moment, where I sit at the moment. The replacement of slavery with indentured labour has long been held as a transitionary point of reference for global capitalist development. For the development of non-Western countries, the institutionalisation of free labour also doubled to signify an important moment in the modernisation process. The instance when arbitrary pre-modern forms of service based on status and customary rights were replaced by market-based contractualism guaranteed by the rule of law. However, in the case of British indentured contracts and the room rental system implemented in Japan after 1873, that argument is too simplistic. The British Slave Abolition Act may have formally freed individuals from bondage, but it did not address the material working conditions of an agricultural system that required unremitting physical labour. The indentured contracts gave individual Asian labourers a legal personality and the freedom to enter in a private contract of employment, but it left the terms of work undefined. The judicial template that defined the employment relationship between the indentured labourer and the employer were British pre-capitalist master and servants laws adjusted to meet the changing colonial contingencies for the recruitment of plantation labour. The room rental contractual agreements were very similar to the indentured servant contracts used by the British to displaced indentured labourers across the globe at an industrial scale. Oops. It too was based on a narrow idea of freedom that defined the work relationship as the performance of service. Japanese authorities too turned to a pre-capitalist legal form to solve the problem of how to enforce performance of service in room rental contractual agreements, and that was debt bondage. The room rental service contract created the conditions for a female to be formally free to enter and nullify her service contract at any time. The woman's loan contract with the brothel owner, however, gave the owner recourse to the full power of law to enforce her service contract. Japanese law made a distinction between what it saw as labour hired out as service and labour that was owed. Service contracts were voluntary contracts which gave the right for women to hire out the property embedded in their person, in this instance the attributes and the capacities of certain parts of a body, to the brothel owner for a period of time for agreed compensation. Owed labour, on the other hand, was the property of the brothel owner and gave him the right to use the woman's body with or without her consent. Thank you. Sorry it took so long.
Thank you so much, Dr Mihalopoulos. We do have time for a quick question. We do have a microphone. If anyone does have a question that they would like to ask, we will be able to make that available. So if you do have a question, pop your hand up. I think there's somebody down the front that might have one. Okay.
Thanks, Bill. That was a really interesting presentation. I actually have a couple of questions, if that's all right.
No, it's not at all.
Just to sort of finish off the story, and forgive me if I missed something, but when the Chinese labourers were released, for example, well, no, the first question is how many were women and what happened to them?
There was one woman.
Okay.
We don't know her age. It's anywhere between 6 and 13, and she was kept in the protection of Herrera, and he actually absconded with her in tow.
Okay, but I think you said some of them made it back to Hong Kong.
No, Herrera went back to Hong Kong with the young woman in tow.
Okay.
He left once he lost the court case. He just absconded.
And the other labourers who were released?
They were all released, went back to China. And,
did they have protection of any kind?
And that's the whole thing. The Chinese government did not officially recognise immigration, so there was no protection from the Chinese government for these labourers, and this was something that the British were keen to try and do.
Right, okay. And my other question is that the images you showed were so interesting.
Yes.
They look like prints, I think.
They're all wooden prints, yes.
But they're all in American collections.
Yes.
So how did that happen? Was that because of the
relationship? What happened was after the Meiji Restoration, the Japanese sort of went on the West is best boom, and they were basically just selling all these things because they thought they didn't have any value, and so American merchants were buying them up in heaps, and because most of these American merchants were from the East Coast, most of them have ended up either in Boston, the Met, or in Washington.
Thank you. Excellent. I think, huge interest in the topic, and I think a lot of questions that people could ask. So I would just ask for a quick round of applause, if we could, for a really interesting talk. And if you'll just indulge me a couple of quick plugs before we do leave. I hope that you'll be able to join us for our next fellowship lecture by Dr Anne Pender, and this will take place this Thursday at 12:30 p.m. And you can see our What's On page for more information on that. And our website is the place where you'll be able to find recordings of very interesting and diverse recent talks and performances from our fellows, which are also available on our YouTube channel. If you'd like to know more about our formed collections, please do search the guide to our collections on our website. And thank you for attending. And thank you once again to Dr Mihalopoulos for a fascinating presentation. Excellent.